Hello.
A very good afternoon to everyone present here. I heartily welcome you all to today's event, a webinar session on POCSO. We have with us Advocate Amit Nalavade sir, who will share with us his distinguished knowledge on the topic for today. I request our principal, Mrs. Shweta Chaturvedi ma'am, to welcome our esteemed guest and speak a few words.
Thank you, Ishrat. Good afternoon, everyone. It is one thing to understand law in classrooms and another to experience it practically. With this thought in mind, the college, with the support of our parent organization, Rahul Education Society, has organized today's event, which will discuss the protection of children from sexual offenses. Rahul Education Society, with the vision of achieving higher levels of academic excellence, has established itself as a reputed quality education provider. Shree Tiwari College of Law, under the aegis of its parent organization and with the vision of our founder chairman, Shree Tiwari ji, commenced in the year 2018, providing law professional courses of 3 years and 5 years. We at Shree Tiwari College of Law constantly strive to ensure our students become excellent professionals equipped with both knowledge of law as laid down in statutes and practical knowledge. Today's event is one such endeavor in that regard, and I thank Advocate Amit Nalavade sir for kindly accepting our invitation. I hope students will learn a lot more about POCSO, its functional aspects when taken up before courts, and the role of legal professionals when dealing with such matter. Ishrat, over to you.
Thank you, ma'am. I take this opportunity to introduce today's guest. Sir has a BSc degree and pursued his LLB from KC Law College, University of Mumbai. Sir has a vast experience in handling criminal matters, particularly those dealing with rape, murder, and POCSO. We have with us today, sir, to discuss on the POCSO, and I request sir to please begin with the session.
So, hi everyone. Hope everyone is safe and vaccinated today. So, let's begin with POCSO. The said act came in force. The said act was enacted on 19th of June 2012. Now, POCSO means the meaning of POCSO, whole definition means the Protection of Children from Sexual Offences Act 2012. Now, let's understand why this act came in force. Now, what was happening? We were already dealing with rape cases under 375 of IPC. But as per reports conducted by National Crime Record Bureau and Study of Child Abuse Act India 2007, they came up with calculation survey that offenses against children are far greater than what we actually believe had been reported. So to curtail these offenses and to take care of such offenses, this act was enacted by the legislature on 19 June 2012 and it came on force on 14th of November 2012. Now, the said act is divided in 9 chapters, 8 schedule and 46 sections. Now, let's go to the preamble of the said act. Now, said act was the act of the preamble of the act is an act to protect children for offense of sexual assault, sexual harassment, and pornography, and provide for establishment of special courts for trial of such offences and for matters connected therewith or incidental thereto. Whereas Clause 3 of Article 15 of Constitution of India empowers the state to make special provision for children. Whereas the government of India has acceded on 11th of December 1992 to Convention on Right of the Child adopted by the General Assembly of United Nations, which has prescribed a set of standards to be followed by all state parties in securing the best interests of the child. Now, here I pause for a few minutes. Now, Convention on Right of Child by the General Assembly 1992, they gave certain directions and certain guidelines were provided, as a result of which this act came to be enacted in our country. Now, the whole purpose is to the whole object of this act was regarding the paramount importance of every state to ensure the healthy physical, emotional, intellectual, and social development of the child. Now, this act has been divided into 54 sections. There are around 46 sections in this. Now, section number 2 is definition. Now I would go directly to section 2D, child. Child means any person below age of 18 years. There is gender equality. It can be a male child or a female child, which is below 18 years. Now here one question can be asked whether a person who is in a mental retarded person who has a childlike brain of 18 and below, whether it will be covered under this act. My answer would be no to that. A proper 18 years has been given. There is no confusion over that. Now, second definition which I would like to cover is the word section 2. The words and expression used herein are not defined but defined in the Indian Penal Code, Code of Criminal Procedure, Juvenile Justice Care and Protection Act, and Information Technology Act. Shall have the meaning under, or rather, if there is an immunity, ambiguity, the same needs to be clear by going to the said act. Now, the sexual offenses against children, section 3, penetrative sexual assault, in short, PSA. Now, as per the definition itself, penetrative sexual assault, we can understand that penetration is an important ingredient. A person is said to commit penetrative sexual assault if he penetrates his penis to an extent into the vagina, mouth, urethra, or anus of a child, or makes the child to do so with him or any other person, or he inserts to an extent any object or a part of the body, not being the penis, into the vagina, the urethra, or anus of the child, or makes the child to do so with him or any other person, or he manipulates any part of the body of the child so as to cause penetration into the vagina, urethra, anus, or any part of body of the child, or makes the child do so with him or any other person, or he applies his mouth to the penis, vagina, anus, urethra of the child, or makes the child to do so to touch such person or any other person. Now, penetration can be not only a private part, but to any extent to any part of the body that do not includes fingers or any part of the body, thereby touching, penetrating the victim's body, private part. Now, this section 3, penetrative sexual assault, is covered with the punishment which is under section 4 for penetrative sexual assault. Now, the punishment for sexual assault under section 4 can be divided in two: a child below 18 years and child below 16 years. Now, child below 18 years, the punishment for penetrative sexual assault shall not less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. So basically, the minimum sentence for PSA for 18 and below is not less than 10 years. It can extend to life and also be liable to be paid by fine. Now, second, under section 4.2, child below 16 years. Now, there is a differentiation, 18 years and 16 years. Now, 16 years been dealt under this 4.2, which says not less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of natural life of that person and shall also be liable to fine. Now, I'll pause here again. I would like to explain that now 4.1 says about life imprisonment for the life, but 4.2 says that imprisonment for life, which shall mean imprisonment for the remainder of natural life. Why this differentiation is there? Because benefit of remission can be extended under 4.1, but not under 4.2. Remission means when a person who has been punished for 14 years comes is sentenced for 40 years and he completes that 14 years, the benefit of remission may go to him. He can be benefited under Remission Act, that is a beneficiary for Prisoners Act, but not under 4.2. And the fine which has been imposed, one important aspect which we needs to look into, that this fine which has been imposed by the court at the time of sentencing, this fine goes to the victim for the medical expenses. Rather, it can be said a compensation to the victim for the mental agony and the physical expenses, mental treatment what he or she has gone through. Now, section 5, aggravated penetrative sexual assault. Now, let's understand what do we mean by aggravated. Aggravated in criminal offense means serious crime which involves violence. Now, here aggravated means, now you would say why aggravated has come into, why they have made a special differentiation for aggravated. Now, aggravated means a victim who has been sexually assaulted by a person whom he trusts. We would say a breach of trust in this case, that distant, near relatives, someone whom we trust, we hand over a child to a person whom we trust, and that person assaults this child, then it will come under aggravated sexual assault. A police officer, a hospital, institutions, a school institution, education institution, hospitals, and all those authorities who are under custody of the victim, and in that custody they commit any such offense, it would amount to an aggravated sexual assault. Now I would add one more point. Aggravated also includes an assault which leaves a physical and mental, rather, agony to the child, would also come under aggravated sexual assault. Now, this sexual assault under aggravated penetrative sexual assault is punishment is covered under section 6. Now, punishment for aggravated penetrative sexual assault. 1. Whoever commits aggravated penetrative sexual assault shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of natural life of that person, and shall also be liable to fine or with death. So 6.1 clearly speaks aggravated is far more heinous than the PSA, that penetrative sexual assault, because it is committed by a person whom we trust, and for which minimum sentence is 20 years. It can extend to life, and even death sentence has been covered under this offense. The fine imposed under subsection 1 shall be just and reasonable and paid to the victim to meet the medical expense and rehabilitation of such victim. Rehabilitation means why? Because the victim may be who's been taken care by that accused. Now, if that accused is inside the prison for his or her rehabilitation, the fine is incurred, and which is paid to the victim. Now, section 7 speaks about sexual assault. Whoever with sexual intent touches the vagina, penis, anus, or breast of the child, or makes the child touch the vagina, penis, anus, or breast of such person, or any person, or does any other act with sexual intent which involves physical contact without penetration, is said to commit sexual assault. Now, I will point out one important aspect while reading this sexual assault definition. For any crime, mens rea is an important ingredient. Mens rea means guilty mind, a guilt with complete knowledge. Now, in this case, section 7 speaks about sexual intent. That means the intention must be very clear that he touched, or rather he committed this act with a sexual intention. A touch which is done unintentionally does not come under this act, but an intention to with sexual motive is covered under this act. As per section 8 speaks about punishment for sexual assault, which is not less than 3 years, but which may extend to 5 years, and shall also be liable to fine. So, while dealing with section 8 and 9, we need to understand one important, that sexual intention, mens rea, is very important ingredient. And this needs to be proved by the prosecution while proving their case. And defense needs to prove that there was no sexual intention, it was an unintentional thing, which a burden is on the defense to prove at the time of the trial. Now, section 9 speaks about aggravated sexual assault. Now, if I say section 5 and section 9 is almost same. Aggravated, now you have understood, and aggravated means one who breaches the trust, who takes advantage of his position and then commits an sexual assault, which cover under this. Now I'll go to section 10, punishment for aggravated sexual assault, which should not be less than 5 years, but which may extend to 7 years and shall also be liable to fine. So here we need to understand, whenever there is an assault by an aggravated, the punishment is also added by 2 years. It's far more serious. And court and legislature had tried to protect, or rather an obligation on the, rather to see that no one takes undue advantage of his position, being a government servant, being a custodian, being the control of that victim, and to protect this such type of cases. This section 7 and section 6 and section 9 takes care of it. Now, section 11 speaks about sexual harassment. Now, day in, day out, we see while traveling in bus, train, or rather walking on the road, in workplace and school institutions, everywhere we see harassment to the victim, maybe male or female. Mostly it is females. To cover the child, to protect the child. Section 11, we need to go through it. Now this we can say that 354 IPC, outraging modesty of a woman, had taken care of it. But we need to understand a child also can be subjected to sexual harassment, which is covered under section 11. A person is said to commit sexual harassment upon a child when such person with sexual intent utters any word or makes any sound or makes any gestures or exhibits any object or part of body with the intention that such word or sound shall be heard, or such gesture or object or part of the body shall be seen by the child, or makes a child exhibit his body or any part of his body so as it is seen by such person or any other person, or shows any object to the child in any form or media for pornographic purpose, or repeatedly or constantly follows or watches or contacts a child either directly or through electronic, digital, any other means, or threatens to use in any form of media a real or fabricated depiction through electronic film or digital or any other mode of any part of the body of the child or the involvement of the child in sexual act, or entices a child for pornographic purpose or give gratification therefore. Any question which involves sexual intent shall be question of fact. It is given an explanation. Now here, sexual harassment is not only by touching, but uttering sexual explicit, or by making sound, or showing any private part of your accused, showing his private part, or making that child show his private part, or making him, or enticing or inducing him or threatening him to remove some sounds, or utter any word, or shows any pornographic clips and videos and to the child, or uses that child for pornography, it is covered under sexual harassment, and which is given under, and punishment is given under section 12. This is which may extend to 3 years or fine, 3 years and fine, and both. So basically, the offenses under POCSO is clearly covered under section 3 to section 12, which a student needs to go through it. Or I would rather recommend prepare a chart dividing it to 3, that is section, the offense, and the punishment, to give a proper clear view about the what offenses is punishment with what, and what are the basic ingredients. So basic ingredient we can say is a sexual intention. With a sexual intention, an offense is committed, which is divided into PSA, penetrative sexual assault, aggravated sexual assault, sexual harassment, and sexual assault, aggravated sexual assault. This is covered under this thing, section 3 to 12. Now, a question is again raised when you, in a practical manner, practical trial court, when we conduct a trial, the question some advocates do ask, now what if the consent is given by the victim, that is a child, either unknowingly or through ignorance? I would like to make it very clear, consent under POCSO is immaterial. Even if a child on his own free will consents to the act of the accused, still that would be an offense under the POCSO Act. Make it very clear. Now, there are other sections which are covered. I would rightly go to an important section of section 16, abetment of an offense. A person abets an offense. An abetment is clearly defined under IPC, and we all know, being a law student and law officers, and abetment is aiding, enticing, and abetting a person who commits an act, or rather helps a person to commit an act. So this clearly covers gang rape cases, and a cases in which one accused commits a sexual assault on the victim, where there are other accused who are standing outside or other abetting him, encourage him to commit an offense. That is covered under section 16, and which shall punishment is given under section 17. Whoever abets any offense under the act, if the act abet is committed in consequence of the abetment, shall be punished with imprisonment provided for that offense. So a person cannot claim that by maine kuch kiya nahi, I did not do anything. The person who was doing that act is that person, but he was there in that offense when the offense was committed, and he aided and abetted that act, and he shall be covered with the main accused for the punishment which is applicable. So we can say section 34 IPC, common intention, and criminal conspiracy, section 120B of Indian Penal Code. We need to go through that definition and understand how a person can abet a thing, abet a crime. So punishment is same whether you actually are directly involved in that, you are actually directly in that said sexual act, or rather you are standing outside and encouraging and that person to commit an act. You will be suffering the same imprisonment. Now punishment for attempt to commit an offense. Now attempt means what? Before an act is complete, if it stop before a completion of act, it means it's an abatement. It's an attempt. So before an act is completed and if it is stopped, it is an attempt. So you cannot say the act is not completed. So to cover that, section 18, punishment for attempt to commit an offense. Now, interestingly, we need to understand the punishment given, that whoever attempts to commit any offense punishable under this act, or to cause such an offense to be committed, and in such attempt does any act towards the commission of offense, shall be punished with imprisonment of any description provided for the offense for a term which may extend to one half of the imprisonment for life, or as the case may be, one half of the longest term of imprisonment provided for that offense, or with fine, or with both. So if an offense is committed to life, so one half of that life imprisonment will be a punishment for an attempt. Now section 19 chapter 5 is section 19 is covered under chapter 5, procedure for reporting of cases. This is very important, because day in day out we see that people who know, they are aware that such and such act has been committed or other is happening in their locality or in their they know about the said offense, but they fail to कि किसी के झगड़े में या किसी के मैटर में क्यों पढ़ना. So with that intention they fail, they do not take any step to rather avoid, rather stop that such criminal act. And this act clearly speaks that if you are aware of some such thing happening, and then if you don't report when you are under, you should have reported, then this section 19 comes into picture. Reporting of offense, notwithstanding anything contained in the code or criminal procedure code, any person, including the child, who has apprehension that offense under this act is likely to be committed, or has knowledge that such an offense has been committed, he shall provide such information to special juvenile police unit or the local police. Every report given under subsection 1 shall be ascribed at entry number and recorded in writing, be read over to the informant, shall be entered in the book to be kept by the police unit. When the report under subsection 1 is given by child, the same shall be recorded under subsection 2 in a simple language so that the child understands the contents being recorded. In case contents have been recorded in the language not understood by the child, or wherever it is deemed necessary, a translator or an interpreter having such qualification, experience, and on payment of such fee as may be prescribed shall be provided to a child if he fails to understand the same. Where the special juvenile police unit or local police is satisfied that the child against whom an offense has been committed is in need of care and protection, then it shall, after recording the reason in writing, make immediate arrangement to give him such care and protection, including admitting the child into shelter home or to the nearest hospital within 24 hours of the report as may be prescribed. The special juvenile police unit or local police shall, without unnecessary delay, but within a period of 24 hours, report the matter to the Child Welfare Committee and the special court, or where no special court has been designated, to the court of session, including need of the child for care and protection and steps taken in this regard. No person shall incur any liability, whether civil or criminal, for giving the information in good faith for the purpose of subsection 1. Now, reporting on offense is a obligation, rather duty of a person who comes to know that such act is likely to be committed or has been committed. So it is duty on that person to report this act, report this crime to the local police station or to special juvenile police unit. Now here there is special explanation. If a child, if he's doing any reporting, he's reporting the crime, so it should be recorded in the language in such a easy manner that the child should understand what are the contents. Now sometimes what happens, that a person may not know the local language, may not know the Hindi, may not know Hindi, or may not know English also. In that such circumstances, the child or the person who is complaining or rather reporting, an interpreter, a person who knows, understand that language, needs to be appointed after paying prescribed fee and seeing to it that it is reported, it is recorded in that language and explained to that person who is reporting the said case. There is obligation on media too, which is covered under section 20. An obligation of media also, the ingredients, the rather definition is quite clear. It is obligation of media, student, photography facility to report the cases. any personnel of the media or hotel or lodge or hospital or club or studio or photographic facility by whatever name called irrespective of number of person employed therein shall on coming across any material or object which is sexually exploitative of the child, including pornographic, sexually related or making obscene representation of child or children through the use of any medium, shall provide such information to the special juvenile police unit or to local police as the case may be. And section 21 speaks about punishment for failure to report or record a case. Imprisonment is up to 6 months or a fine or both. And any person being charged of any company or an institution who fails to report, his punishment is up to the extent of 1 year and fine or both. Now, section 22 covers punishment for false complaint or false information. Now, this is a growing trend which we while practicing in criminal court, we have noticed some cases are also false, in which accused has been falsely implicated. And it's a very serious issue. Time and again, we have raised this issue because once an FIR is registered, it's a cognizable offense. Accused is arrested there and there. So our request to the court was that if a recommendation is made before an offense is registered, even if offense is registered, before arresting a person, a proper verification is done to find out the genuineness of the said complaint. Now, section 22 speaks about punishment for false complaint or false information. Any person who makes false complaint or provides false information against any person in respect of offense so and so, with the intention to humiliate, extort, or threaten or defame him, shall be punished with imprisonment for term which may extend to 6 months or with fine or both. Where a false complaint has been made or false information has been provided by child, no punishment shall be imposed on such child. If a child makes a complaint, no punishment. But other than child, punishment is given. Whoever not being a child makes a false complaint or provide false information against a child, knowing it to be false, thereby victimizing such child in any offense under this act shall be punished with the imprisonment which may extend to 1 year or with fine or with both. Now, this we need to understand. There are cases in which some parents claim that their child has been molested by another child. So under the circumstances, and it turns out to be false, then under this circumstance, the punishment under such cases is 1 year, which may extend to 1 year of fine or both. Now, chapter 6 deals with procedure for recording statement of child. Section 24, recording of statement of child. So this section speaks about recording of statement of child. It has to be recorded as per the convenience of the child in the same safe atmosphere by a lady sub-inspector or lady sub-inspector, not necessarily in police station, but whichever place the child feels comfortable and in presence of her or his parents. Now, section 25 speaks about recording of statement of child by magistrate. Now, we are well aware of 164 CRPC, that is confessional statement of the accused to the magistrate. But in section 25, speaks about the confessional, rather a statement recorded by magistrate of the child. So once an FIR is registered, statement of victim is recorded, a step ahead to protect the child, or rather see to it that the child continues with the trial. A 164 statement is recorded by magistrate, which has far greater weightage. Now, section 25 speaks about the recording of statement of child by magistrate. Now, said statement is recorded in presence of the can be recorded in presence of the child's parent. There is no dispute. Section 27 speaks about medical examination of child. The medical examination of child in respect of whom an offence has been committed under this act shall, notwithstanding that first information, report, or complaint has not been registered for offence under this act, shall be conducted in accordance with 164A of CRPC. Now, here what happens, sometimes a child is seen on the road who needs urgent medical care or other treatment. She is immediately taken to hospital. Now, just because she is subject to any sexual assault or offense under POCSO doesn't mean an FIR needs to be registered prior to her medical examination. Her medical examination needs to be given prior importance. And under this circumstances, section 164 of CRPC, which covers medical examination, is dealt with in under section 27 of medical examination of child. Section 28, chapter 7 speaks about designation of special courts. Special POCSO courts have been formed to deal with such cases. Presiding officers are mainly lady female judges are there, female staff is there, female public prosecutor are there. In my initial days, I had asked the judge why only female judges, why not a male judges? What my judge madam had given me an explanation that a child is very close to his mother, his or her mother. Now, under these circumstances, That is the reason, looking at that paramount interest and interest of the child, female judges have been appointed. Now there are some cases which are dealt by male judges also, but those are pertaining to 377 of that is unnatural sexual offenses and minor offenses. Then section 2930 is very important, speaks about the presumption. Now I'll pause for a minute and I would try to point out to this point out that in criminal matters, presumption of innocence is always in favor of accused. But here there is this act which has a contrary presumption. Now, burden is not on prosecution to prove the guilt of accused beyond reasonable doubt. In fact, section 29 and 30 speaks about a burden is on the accused to prove his innocence beyond reasonable doubt. Let me be very clear. Burden is on accused to prove his innocence beyond reasonable doubt. Because 29 and 30 begins with the word where a person is prosecuted under committing or abetting or attempting to commit an offense under this act shall presume that such person has committed or abetted or attempted to commit the offense as the case may be unless the contrary is proved. The word shall has been used means it is compulsory consider that accused has committed an offense. Burden is on the accused to prove his innocence. So we cannot take a benefit that normally we see in criminal cases that weakness of defense cannot, prosecution cannot take the advantage of weakness of defense. In this act, the burden is on the defense to prove his innocence. Even if prosecution is weak, but FIR has been registered, victim gives a testimony in very clear words against the accused. There may be other small lacunas here and there, still the advantage won't go to the accused unless he proves his innocence beyond reasonable doubt. Then section procedure for and power of special court is dealt under chapter 8 under section 33. A normal CRPC, the manner, the sections are covered under Indian Evidence Act and CRPC, the manner, the mode of conducting the trial and recording the evidence. Section 35, period for recording of evidence of child and disposal of case. The evidence of child shall be recorded within period of 30 days of 30 days of the special court taking cognizance of the offense and reason for delay, if any, shall be recorded by special court. The special court shall complete a trial as far as possible within period of 1 year from the date of taking cognizance of offense. Now, when does the cognizance taken? Whenever the matter reaches the court, that time the cognizance is taken by the court. Charge is framed, cognizance is taken by the court. So law is very clear, within 30 days of the cognizance, the victim's evidence has to be recorded and trial has to be completed within 1 year from the cognizance of the court. But in practical, there are so many matters and so less courts. This is practically in books only, but but not in practically it is not possible to cover the trial in 1 year. This is my experience. I may be wrong. There are, we see there are certain cases which can be completed in 6 months, but there are so numbers of the number of cases, and the courts are very less to deal with such cases. So the state and central government are they are child not to see accused at time of testifying. The special court shall ensure that child is not exposed in any way to the accused at the time of recording of the evidence, while at the same time ensuring that the accused is in position to hear the statement of the child and communicate with his advocate. For the purpose of subsection 1, the special court may record the statement of child through video conferencing or by utilizing single visibility mirror or curtains and any other devices. Now, this child, when the child comes to give his or her evidence in the court, a precaution is taken to see the child evidence while she is giving while the child is giving evidence. The child is kept away or other position in such a way that the child does not see the accused. That fear factor needs to be controlled because the victim is under fear of the accused. So the precaution is taken that accused is kept away from the child. No doubt, advocate for the accused is present when the evidence is recorded. And so this is covered under section 36. And section 37, trials to be conducted in camera. The special court shall try cases in camera in presence of the parents of the child or any other person in whom the child has trust or confidence. Provided that where the special court is of the opinion the child needs to be examined at a place other than the court, it shall proceed to issue a commission in accordance with the provision of section 288, 284 of CRPC. Now, trials to be conducted in camera does not mean that there is some video recording. General perspective that in camera brings the camera in picture. But in camera means in the chamber of the judge, or other in court when there is no there is except the child and the advocate for the accused and the court staff and the judge, presiding officer. There is no other person, no public is there. So we call it in camera. But generally, we see that victims evidence is conducted inside the church in the judge chamber in the privacy to make her comfortable at the time of giving evidence. Then section 38 speaks of assistance of the interpreter or expert while recording evidence of child. So whenever any expert or interpreter is required, assistance is taken for the conduct of the trial. No other things. So this act is very clear, which is divided under 8 schedules and 46 sections. Now, there was an amendment under this act on 15th of March 21. Sorry, on 15 March 21, Juvenile Justice Act, there was an amendment in which in case of heinous offense, now Juvenile Justice Act deals with the child below 16 years. But in case of heinous offense, the child who is an accused who is 16 years and above shall be dealt as an adult in heinous offense. Now, here we after going through this act and in my practical experience, which I have gone through in my last 12 years of practice, I've conducted more than 70 trials under POCSO and other criminal cases. Dealing with POCSO is far more serious and far more rather challenging, for only reason that presumption of innocence is not there in favor of accused. So when we are conducting a trial, we see to it that defense is very firm. So in my 12 years of practice and 60, 70 trials, what I have noticed that false cases cannot be ruled out. I've seen offenses where I've seen that I've conducted trial, a father has been alleged as an accused of committing sexual assault, penetrative sexual assault against his own daughter. A grandfather is also included. A grandfather is also included in the said case because of family disputes. Neighbors are being included in the case because of neighbor enmity. So there can be many reasons for false implication. So as a defense advocate, we need to firmly establish our defense from day one. We cannot change our defense in this POCSO. In other cases, yes, you can have an alternate defense, but in POCSO, what I found out that your defense needs to be firm from word go. I'm not saying that there are not genuine cases. Yes, there are cases in which I would not name that accused and the police station which has registered that case. A natural father was arrested for rape of his own daughter. So I was appointed on the very first day of the remand, and when I spoke to him, he said, "Darucha nashet kai झालं मला कळालं नाही." I was so shocked because this was in initial days. I got my son in 2010, and this act came in 2012. So I was shocked to see that a natural father can act or rather commit an offense against his own daughter. And I was shocked, and I questioned him, what made you did not even think for a second that is because the victim is your daughter. He said that he had lost control over his senses and he committed this act. Later on, he was convicted for the said offense. So in this 12 years of my practice, I've seen genuine cases as well also false cases. But again, I'll tell you, or rather point out, that moral conviction cannot be moral ground cannot be a conviction point. It has to be a legal ground. Just because a judge feels that morally this accused is done wrong, but there is no legal evidence, she cannot convict an accused. There has to be legal evidence. And without legal evidence, there cannot be a conviction. So to complete my this lecture on this POCSO, in conclusion, I would say that students needs to understand the legal terminology of these offenses and their basic ingredients and the motive for enactment of this said act and the procedure for conducting a trial. What we learn in books, what we learn in colleges, law colleges, and practically what we apply in courts is quite different. A practical experience we need to go through for conducting a trial. And a trial advocate needs to be a responsible person because see accused life is at stake. He may be guilty or innocent, that is judge will decide. But once you have been appointed, you need to give 100% by going through the charge sheet, going through the act, finding out the lacuna, and preparing yourself for the cross examination of the witnesses. In these cases, in POCSO cases, victims' evidence is far more important. I would rather say is very important. But law, Supreme Court from time and again have stated that child's testimony needs to be taken with precaution, because she can be subject to coercion, to tutoring, cannot be ruled out. So while dealing with child's evidence, the court also takes care that it is supported by some corroborative evidence. No doubt, it is tough to rather deal with child witnesses, but still, it's a challenging affair which I've seen in 12 years of my career. I have conducted 80 trials, almost 80 trials, in which I've succeeded in equating more than 50 cases. In the end, I would only say that this very challenging profession, law and trial advocate is a different game altogether, and you need thorough preparation before conducting and taking up trials. And for students' benefit, I would advise them to read S. Vardarajan case 1977 AIR, in which deals with the minor love affair wala, and Sunil Mahadev Patil Bombay High Court judgment, which is on bail under POCSO. And there are many more cases. So we need to understand the act. We need to understand what court's view is there as per this act is concerned before reading after reading this act, and to understand the act thoroughly. Thank you. I'll conclude with my I'll complete my lecture. Thanks.
Thank you, sir, for shedding some light on the POCSO Act. We'll take up a couple of questions which
Yeah.
we have. So, the first question is, how far are the procedures child friendly?
How are the procedure child friendly? Now here
Yes.
we need to, the act is very clear. Whenever the child's evidence, child statement is recorded, is recorded in a place in which the child is comfortable, in presence of a person with whom he or she is comfortable. So it's not necessarily child statement has to be recorded in police station. What is general view we think about? It can be recorded in the child's own house or any place in which he or she is comfortable. So as far as child statement is concerned, it can be recorded in comfort zone. While conducting medical also, a precaution is taken or other guidelines is there. A lady doctor has to be there in presence of his or her parents. Okay. And when at the time of trial also, precaution is taken that child evidence is conducted in camera. That is, accused has been to keep your child away from the accused, and it is conducted in the judge chamber in presence of female public prosecutor and female staff. So the child becomes comfortable, and that precaution is taken to see that the evidence is given in proper fashion. Anything else?
Yes, sir. Another question is, according to you, should mental age be considered under the Act?
I would say yes, because numbers are only figures. Okay. Why I said S. Vardarajan? Because in 1977, three bench Supreme Court has said that a minor who on his own leaves the company of the guardian, so that cannot be a kidnapping. That does not come on, it is covered under that S. Vardarajan case. So mental age of a person needs to be taken into consideration, because a person with mental retardation who is maybe 40 years and has a childlike brain. So even that person can be subjected to sexual assault, taking advantage of his mental disability or mental childlike brain. So it needs to be covered under this act, looking at the paramount interest of the welfare and welfare of the society. In my recommendation, yes, it should have been covered.
Okay, sir. So, what is the compensation scheme, particularly when there is when the victim is has died? So, if is
In
it
case of
like
compensation,
appropriate? Yes.
very good question. Compensation when victim has died, the compensation goes to the parents of the victim for the agony and mental loss what they have suffered, and it is given by the state government. There is a panel for it which decide what the compensation will be and what the age of the child is. Now if a child is at the age of attending a majority, maybe tomorrow he or she could have earned some money for the parents, could have been a source of livelihood for the parents, and that this circumstance they look into it. But where the victim is not, has not died, and she is other offenses, state government and central government, they give compensate victim minimum is 50,000 and above. Now here, because of that, what has happened, what we have come across in this 12 years of my career, many false cases have been filed just to cover that compensation. This is very tragic true fact of the life, that this act has been misused by so many people just to recover the compensation. Okay.
Yes, sir, agreed. And just a final question. Sir, if you could guide our, law students as to begin their practice in this particular field, because not many understand the nitty-gritties and want to take up. So if you could just inspire them to take up this, with your few words, that would like really help.
See, whenever now around three juniors have been assisting me in my last 12. Currently, three juniors have been assisting. More than 10 juniors have assisted me in last 12 years. I got my sanad in 2010, but I was assisting Mr. Ashok Gupte, AP Gupte in anti-corruption since 2008. So prior to my dig sanad, I was assisting Mr. Gupte in conducting a trial. So you have to be very clear in your vision whether what you want to become. You want to be a litigation lawyer or you want to become a corporate lawyer. If you want to be a litigation lawyer, you need to enter the court before you get a sanat, so to get the feel of the court. So sanat is mere a degree. Okay, it's a degree to giving you a permission to conduct to appear in the court. But I want to say that you should be ready, or rather you make yourself comfortable before you get a degree, by preparing yourself, by entering the code and see the atmosphere, how things are working out. So you get a practical knowledge. Reading law, learning law in colleges is a different thing, and applying that law in the code is a different game altogether. I did my law in KC Law College. There were 200 students. Now, out of those 200, I was topper in all the 3 years of my law college. Out of all the 200 students in today's time, there are only hardly 3 to 4 students who are my classmates who are in the courts conducting trials. That means 196 students who passed out with law, they are into corporate practice. So being a trial advocate, if you want to become a trial advocate, you need to enter the court at very early stage before you get a degree, to get the feel, just to get the feel, to see how the advocates are conducting trial, how they are making submission, how the procedure are being followed, how the court are questioning the advocates, how they are replying, to see the decorum of the court, how they are or rather how they are conducting themselves inside the court. That gives a very good practical experience. And when you do, you get your sanad. When you appear before the court with this knowledge and with this experience, you start from word go. Okay. So in my case, very first day when I got my sanad, I appear in the court, filed my wakalnama, I reviewed the matter, I got the order at the very first day. Because of what? Because I started assisting 2 years prior to my sanad. So that gave me a lot of great experience of practical knowledge, and which helped me in my practice in last 12 years. I've been using that experience. So, and the second thing which I would like to tell is not filmy, but to understand law, you should love law. You see, our acts are so vast. इतना पढ़ने को किसको time मिलता है? ऐसा नहीं, unless you show interest, you should need to fall in love with the law to understand the law. This is my practical thing. I used to study 14 hours during my exams, before my exam. To एक चीज, एक small things in a small interpretation changes the course of law. Things are so difficult, and you need to interpret in such a easy fashion. You need to interpret and to understand. You should fall in love, and you should read. Keep on reading text. You keep on reading. Internet is such a big source of finding what is happening in India in various courts. Go to those sites, indianqanun.com. You go to that site and you will find out thousands lakhs of judgments on one point. Then Maharashtra Law Journal is there, AI is there, and Crime Reporter is there. A student needs to read those journals to understand what was the law, what was the ratio of that case, what was the defense of that defense in that case, and what was the judgment, and what point the judge gave that judgment. You need to understand that. This is what I would rather suggest my student friends to do.
Absolutely. Thank you so much, sir, for
Thank you.
guiding all of us with your knowledge and experience.
It was
Also, I take this opportunity to thank all of our students, our audience who have been a witness to this event today. As well as I would like to thank our principal ma'am as well as the management for their efforts and constant support to conduct such events and guide our students in every way possible. So thank you so much to everyone who have joined today. Uh, we conclude the event here.
my pleasure. Have a nice day. Best of luck.
Yes, sir.
Thank you, sir.
Thank you, sir.
Thank you.